for today is 2020-51032, Pierre versus Vasquez. Yes. Mr. Gladden.
Good morning, may it please the court. May I remove my mask?
You may wear or remove it at your choice. And can you turn it down just a little bit? We're getting too much reverberation in the room.
Okay, thank you. Good morning, may it please the court. The appeal that we have before the court this morning primarily involves two separate issues. One has to do with a procedural error that the appellant claims with regard to the conversion of a motion to dismiss under Rule 12 that was converted into a motion for summary judgment under Rule 56 by the district court. The second issue deals with the question of legal standing that does not get to the merits, as questions of standing wouldn't, but deals with what the applicable law would be to determine whether someone has standing based upon an alleged liberty interest. And I'll treat those separately and in the same order. In this case, the defendants, that is the appellees, had filed a motion to dismiss alleging a single ground for their motion to dismiss. That was the plaintiff failed to state a claim because they had, as a factual matter, been convicted of an offense that required registration as a sex offender under the Sex Offender Notification or Registration and Notification Act, known as SORNA for short. Texas law incorporates and in this context would determine whether someone is required under Texas law depends exclusively on an interpretation of federal law. That is a provision under SORNA that says anyone convicted of a federal offense or military offense is required to register under SORNA. And on that basis, Texas has a special provision for people to be required to register under Texas law if they're not otherwise required to register under Texas law, provided they had been convicted of a sex offense. Motion to dismiss. We had a conference prior to, we had scheduled a trial, actually had a bench conference, and both parties as well as the district court agreed that we could hear this matter, that both parties would remove their pretrial dispositive motions, that is including the state or appellee's motion to dismiss, and that we would have a bench trial. And then when the bench trial date came close, because of the coronavirus, the judge had another, I believe it was a telephone conference, and determined that we'd have to postpone indefinitely the bench trial because of the coronavirus. Then a month or so after that, the district court then sent an order to the parties saying that it was reviving the state's motion to dismiss and didn't mention what the sole ground was, but just said, I'm reviving it and I'm converting it into a motion for summary judgment. Both parties have, I guess it was 10 or 14 days, to provide additional materials responsive to that motion to dismiss. And of course, I didn't respond because the whole case has been about whether my client was entitled to notice and an opportunity to be heard before factual determinations. That is, under SORNA, there's an exclusion that says that if someone the criminal conduct involves consensual sexual conduct involving an adult victim and the victim was not in the custody of the defendant, then SORNA expressly says that is not a sex offense defined under federal law. And there's no evidence to show that my client is anything other than entitled to that exclusion.
Remind us, did you file something that explained that again to the district court? I know you had.
Absolutely. It was.
Okay, so you didn't file evidence, but you then filed.
I filed evidence as well.
You filed evidence, because you said I didn't respond to that whenever the judge said.
When the judge gave the notice of the conversion, neither side, and including my client, responded with additional evidence to deal with the
Because you had already put it in on the motions to dismiss.
The only party that put evidence in the record was my client, the plaintiff.
Okay.
And we had affidavits, we had the plea.
Right.
Volumes of information.
Does this turn on whether he was convicted of a sex offense, or do we not need to decide that?
It turns on whether that exclusion under SORNA applies, which are three questions. Was the victim an adult? In the plea papers, he says it's an adult female in the allocution, all right? Was it consensual? It was solicitation of prostitution, a Mann Act violation across state lines. And number three, was the victim in the custody of the defendant at the time of the offense? And as the allocution also says, he agreed to this thing where this 25-year-old female would come from Phoenix. He'd meet her at the Greyhound station in Houston. When he arrived there to pick her up, he was arrested. So the victim was, there's no question the victim was never in his custody. And so those three factual questions are what need to be resolved, and nobody is claiming that the state has any evidence.
Well, but didn't the state board of registration exercise its discretion to opt out of that exclusion?
No. They determined that there's an email between the Sex Offender Registration Bureau, Texas, part of the Texas Department of Public Safety, where they emailed my client and said, we can't determine whether you're required to register or not. So we're going to actually, that was a witness as an exhibit that was presented for contemplating a trial, where there's another person who hasn't filed a suit but may very soon, a gentleman named Swindle, where he had emailed with him and said, this isn't a sex offense. And they said, we can't tell. So unless you get a court to make a finding that you're not required to register, we're going to presume conclusively that you are without a hearing or an opportunity to be heard.
But it's not because they're opting out of the...
No, it's not an opting out. It's just saying we don't have to, they're saying we don't have to provide procedural due process. And so we're not going to. We don't have evidence to show the negative, that is that you're not required to register. And so they shift the burden to someone, they can have y'all register.
If they did opt out, then what would...
They could, and then they'd say, you show us proof that you haven't committed a sex offense.
If they did opt out, what would your argument be?
I'm sorry?
If the state did opt out, what would your argument be?
I don't think the state can opt out of the 14th Amendment.
Well, if the federal statute, notice he was convicted of a sex crime under federal law, but he was until you get to that exclusion. He wasn't. All right, tell me why that is.
It's not an affirmative defense under SORNA. It's a definitional provision that says this is not a sex offense, all right? And in federal courts, before someone can be required to be on supervised release that requires sex offender registration or sex offender treatment, the district judge has to make a finding, giving the defendant an opportunity to be heard, and then makes a finding whether they have committed or been convicted of a sex offense or not. The procedure followed by the state of Texas is we can decide anybody's required, and unless or until at some later date they come forward with conclusive, actually I think was the word they used, conclusive or certain evidence that they are not.
So he's never been adjudicated in any context as committing a sex offense?
No, and the plea papers make, in the criminal case in Phoenix or in Arizona, make clear there never was an allegation of a sex offense. There was a second count that had to do with coercion, which would have placed it outside the exclusion, but that was abandoned by the U.S. Attorney's Office. And the conditions, the federal supervision don't have any finding. The federal judge never made any finding, the criminal case judge. And so what happened in the district court in this case is that instead of giving us notice and opportunity to respond to an issue that the judge raised sui sponte, and of course it's our position that both Rule 12 and Rule 56 require not just a generalized, if you filed any pretrial pleadings, then that's all the notice you get, and the court can sui sponte pick out an issue that's never been raised and dismiss a case sui sponte. That's what happened in this case.
How much notice did you have after the court told you he was going to consider it as a summary judgment?
I believe he gave us 14 days, but like I said, it was he said provide additional evidence on the motion to dismiss that's been converted, and there was only one issue in the motion to dismiss, and that was he's been convicted. it had nothing to do with standing.
Well, if he wasn't entitled to due process, he'd have no injury, would he?
No, he wouldn't.
So,
He would have a liberty interest. He wouldn't be entitled to additional procedural due process. And that's what Connecticut versus Doe.
if he was convicted of a sex offense, most of the cases, all of them I've seen, say that that's all the process is due.
That's absolutely correct.
But your point is he was not ever convicted of a sex offense, so he's got a process and a liberty interest, both.
And as a matter of fact, the case you're referring to, Connecticut Department of Public Safety versus Doe, the Supreme Court expressly says we're not dealing with whether the person has a liberty interest. We're just saying that once somebody's convicted, they've been given notice and an opportunity to be heard. And the only fact dispute in Connecticut versus Doe was whether he had been convicted, and that was conceded. Both sides said, yes, the person's been conceded.
Why don't they have a list that says these are sex offenses that you're convicted of, and you go off of that? I mean.
Sure. I mean, yeah, SORNA says, and there's been a.
We've had a number of these kind of cases.
Yeah, and the problem is that when the federal district court does not make a finding on whether it's a sex offense or not, then the state of Texas can just choose anybody they want to, notwithstanding the fact that there's factual disputes. Y'all probably have cases where you have to go through this categorical approach or modified categorical approach or fact-based categorical approach in making determinations like that on enhancements or the use of prior convictions for enhancement and for sex offense conditions of supervised release. And the problem has been is district courts are copying and pasting from the sentencing guidelines that say if the person's convicted of a sex offense. And so I've seen it in some judgments where the district court just copies that as a condition of supervision. If the person's required to register, or if the person's been convicted of a sex offense, then they have to register.
And then probation makes that determination, or helps them make.
No, it's not a determination. It's just it's delegation of the question to someone other than the district court.
Right. Well, that's an issue for a separate appeal.
Well,
It's not here.
let me get back to that opt-out provision. The guidelines or part of the regs under the federal statute says the Department of Justice has noted that in all situations, jurisdictions have discretion to exceed the minimum standards of SORNA and require registration upon conviction based on consensual sexual conduct. Now, if Texas had exercised its discretion, then why wouldn't he be guilty of the federal sex crime? That would just take that.
Okay.
That would take that exception out of the statute.
Okay. We don't. First of all, the state statute says if there's a federal conviction. Okay. If the state of Texas wanted to say it can be something else under a statute that they enacted, saying they can be convicted of a federal offense or not. Let's say they don't have to be convicted of any offense. We can just say someone publicly intoxicated is a
But this is a federal statute that says that.
There's a federal statute that defines what a sex offense is under federal law. Texas says if the person meets the definition under federal law, then they're required to register under Texas law. The whole issue about discretion was not that I'm admitting that my client was convicted of a federal sex offense. I'm just saying because SORNA sets minimum standards, the state legislature, if it wanted to, could encompass a broader range of people that would be required to register for offenses that would not require them to register under federal law.
But you'd still have to go through process, wouldn't you?
Yeah, and there'd have to be a statute that said that. And there's not a statute in this case that says a broader number of people are required to register under SORNA.
It says if you're convicted of a sex crime in another jurisdiction, then you will be required to register under Texas law.
Only if Texas law required you to register when you came to Texas.
I thought all it was required was to show that he had been convicted of a sex crime in another jurisdiction.
No, SORNA only requires registration in interstate commerce if you've been convicted of an offense defined by federal law, SORNA. So if you go to a state that has a broader definition under its state laws of what is a sex offense, that state law can require you to register, but you could not be prosecuted for interstate travel without registering under federal law unless the conviction was for an offense defined by SORNA.
Well, he was convicted of an offense that under federal law was a sex crime, unless it was a crime of consent. And if Texas opted out of that exclusion, I don't understand why he wouldn't be convicted of a sex crime, a federal sex crime.
Okay, well, number one, Texas has not opted out of anything, all right? Number two, the statute speaks for itself, and it says that if someone's not required to register under Texas law, but they've been convicted of a federal or military offense as defined by SORNA, then Texas will require them to register. And so they're not opting out of federal law. They're saying federal law is the determining factor.
Right. I agree with that.
Okay, that's true. Okay, it looks like I need to reserve the remainder of my time. I appreciate it.
Thank you. Ms. Cherry?
Okay, is this okay?
Certainly.
So my name is Kathryn Cherry.
Speak up a little bit, please. I'm a little hard of hearing.
My name is Kathryn Cherry. Is that better? Or,
Yes, that's better.
and I represent the state of Texas in this case. I think what I'll do is I'll just go through the questions that y'all have already asked the plaintiff's attorney. So first, in terms of the standing question, I agree with you, Judge Davis. The question is, can he show that there was a violation of due process?
I don't understand that at all. I mean, that's not the way we would normally do standing, right? I mean, that's the question on the merits. And the question on the merits is, does he have a valid 14th Amendment claim? But he's absolutely 1,000% injured in fact by getting a letter from Steve McCraw that says you must register as a sex offender. Like that, I don't know. I have read this district court opinion I don't know how many times. I'm hoping you can help. And I realize you didn't write the red brief, and I understand that. So, but I was hoping that maybe this morning we could unpack a little bit. Injury in fact, absolutely. Getting a letter that says register as a sex offender constitutes an injury in fact. It's absolutely traceable to the letter that Steve McCraw wrote, and it's 100% redressable by a district court opinion, or in this case, a 345th district court opinion in Travis County that says, in fact, you don't have to register. So if we're just talking about standing, which I understand is the only thing in front of us today, I'm confused by why we're talking about the 14th Amendment at all. Why would we just not reverse this 100, like, easily? Call it a day.
So first, I think that both the merits and this question are before the court, and I also think that it's might not even have to get kind of to the particularities of standing, because the question was just, did the plaintiff have sufficient notice before switching over from a motion to dismiss to a motion as per summary judgment?
Well, there's like a bunch of problems with the district court dismissal, right? So one, it's a 12B1 dismissal. It says I do not have subject matter jurisdiction. So that's not a merits determination, that's a jurisdictional determination. And two, it dismisses with prejudice, which is the opposite of a 12B1 dismissal. That's a 12B6 dismissal. So I just, like, I'm befuddled.
Yeah, I think, as you said, I wasn't there, and so I can't speak exactly to what's going on, but I think that the purpose of this was just to send the meritorious or potentially meritorious state claims back to state court. And so that's why they were dismissing with prejudice. But I also
Well, if it's dismissed with prejudice, you can't go back to state court. You're raised
sorry, dismissing our claims with prejudice, so that
Well, if Mr. Pierre's claims are dismissed with prejudice,
not all of them, just the federal claims are
his due process claim, that can't go back to state court. That's raised
No, that won't go back to state court. I'm sorry, I was talking about that he'll now be able to move forward with the state law claims.
Got it.
That he has. But here, I think that I'm not exactly sure how on point the language was, but the idea I think that the court was just trying to get to is just as a matter of law, there's no cause of action here. There's no claim here. But what he meant by that was just you can't, and I mean, it does get into the merits, but I think it's just kind of all of a mix, almost like a Lujan kind of issue where you're looking kind of elbow deep in the merits.
Cherry, you're letting your voice trail off at the end of the sentence. I'm having trouble hearing you.
So I was saying that it is a little bit tied into the merits, but I think the question is just, do you have an injury that is, I think a little bit, this is tied to redressability a little bit, but, and he basically, and Judge Eagle said, no, you don't have an injury because you don't have any, you suffered no due process violation here, no 14th Amendment due process.
Registering, if you're not supposed to register, is a due process violation.
Certainly, Judge Elrod.
When you haven't had any process to determine whether you're supposed to register. I don't understand when you said a minute ago, well, at one point you said that we had to decide the merits, and then you said, well, the merits are just into the, I guess in the Lujan context, they bleed in the analysis. So which is it? Are you saying that we have to decide the case on the merits, or are you saying that we have to just decide the standing? And the standing has some, you get to peek at the merits to look at the standing. Which are you saying?
That's a good question. I think my answer is probably going to be more toward the second, where there are certain steps you can go through without deciding every question presented.
Well, why don't we, what would be wrong with us saying that, yes, he has standing, Judge Jekyll, please take another look?
I think that would be wrong because I don't think he really can prove an injury in fact. So he would have an injury in fact if he had not been convicted of a sex offense. So if he had not been convicted of a sex offense, and then he was told he had to be on the sex offender registry, and now he had a legitimate fear.
He says, I have not been convicted of a sex offense. That is his claim.
But that's incorrect under the law. So you couldn't just have a claimant come in and say, okay, despite the fact that, under 18 U.S.C. 2421 in 2016, I pled guilty to this.
You can actually. You can say, I was not convicted of this. And then, and you have standing, and then on the merits you could lose because they proved that you were convicted of that.
Right.
So that's a merits determination of whether in fact you were actually convicted of that. But your claim that I was not, so I should not face consequences, you have standing to make that. It's just it may fail on the merits if you're correct about the law.
No, I'm sorry, you're right. And I admit that part of Judge Eagle's opinion is a little bit, I think he could have dismissed on just by saying there is no due process right. You don't have a 1983 claim here, and I refuse to accept supplemental jurisdiction over the other state law claims.
So let's go with this for a second, because let's just assume, for the sake of this morning, that this is like the merits question is in front of us, and the question is whether, in fact, or as a matter of law, he committed a sex offense. I've looked at SORNA. I've looked at the state of Texas's list of registrable offenses in the Texas Administrative Code. I've looked at the Texas Criminal Code of the Code of Criminal Procedure, Chapter 60.01, subsection 10, the definition of registrable offenses in Texas, and I've looked at the concomitant provisions of Arizona law. I've not seen there, or frankly anywhere, where a 2421 offense is registrable under SORNA. Are you aware of a single case, a single defendant, a single offender anywhere in the United States who has had to register under SORNA after being convicted under 2421? Because it doesn't say anything about non-consensual activity. It's not an element. That's the problem with this.
So no, but if you give me a chance
Please.
to explain. If you look at the, so trafficking or transporting an individual for purposes of prostitution as an offense under 18 U.S.C. 2421. If you look at 2426, which describes repeat offenses, it refers to 2421 as a sex offense. And so just under the actual language in the statute or in that chapter, 2421 is a sex offense.
If you do it twice?
No, it's just referring to, it talks about repeated offenses and among the prior sex offenses or offenses under.
Was there any allegation that he committed a repeated offense?
No, it doesn't, I don't know if I'm clarifying it, but it would be as if it were saying And I can get you the language, but specifically what 2426 is saying is, when I refer to repeated sex offenses, I'm referring to the sex offenses listed in Chapter 117, which is this transportation one. So just looking at the statute, Congress clearly meant for this to be a sex offense.
So here's
Another thing that you can,
please go ahead.
another thing you can look at is this court's opinion in United States v. Schofield. And in that case, they said, we're just looking for the kind of common meaning of the term sex offense, which would be an offense with a sexual element. I think that if the sexual element hadn't been proved in an adversarial proceeding, then you would have a problem like you would have with the Meza case, or the problem that plaintiff claims he has here, which is that there hasn't been proof of the sexual element, so this isn't a sex offense. But in terms of trafficking or transporting a woman for the purposes of prostitution, the prostitution part is an element that you have to prove, and so now we have both 18 U.S.C. 2426 and U.S. Schofield saying this is a sex offense, done.
So here's the thing.
So
is your position that the District of Arizona, in sentencing your friend on the other side, violated federal law by failing to order in the supervised release conditions that you have to register?
no, Your Honor. If you look at the sentencing, I was trying to figure out exactly what happened in Arizona. If you look at the sentencing guidelines, the proposed guidelines for supervisory release and for probation don't list sex offender registry instructions unless it involves a minor. And the same thing happens with...
I'm looking here at 18 United States Code 3583, subsection D. The court shall order, as an explicit condition of supervised release for a person required to register under the Sex Offender Registration and Notification Act, that the person comply with the requirements of that act. So federal law, if it's registrable, specifically says it must be set out in the supervised release conditions, and as I know you know, it was not.
Well, I guess I'm kind of coming at this from two ways. One is it a sex offense? And then the second one is it registrable? And perhaps the District Court of Arizona, taking all of SORNA as gospel, is saying, sure, it's not registrable under SORNA, or it is. I don't know. I think that what probably would have been better is if there had been an appeal and we'd asked the court to correct that opinion to add in those additional requirements. But I guess my point was that in terms of the notices that these inmates get or these offenders get, the sentencing guidelines seem to only say, only add it if the person is a minor. And if you look at Arizona's state sex offender registry, which I took a glance at, it also really focuses on offenses against minors, and then I think like public indecency. In other words, it's very unlikely, and it's, I think, a burden that we don't want to give courts to have to know where under every state's law this person may have to register, right?
So now
Those requirements are constantly changing, and as Judge Davis said, a state could even look at SORNA and say, I actually don't want to do this provision of SORNA, and so even if you're going that way, you're still not necessarily giving the inmate all the information that, you're not necessarily giving the inmate correct information.
So now I'm even more confused, because I thought the point was that this is registrable under federal law. So I was very confused as to, because that's what the district court said, that's what your brief said, that's what the motion to dismiss for failure to state a claim in the district court said, is that the position of the state of Texas is the offense committed under 2421 is registrable under federal law, not that Arizona has opted out of anything or that Texas has opted out of anything. I think everyone agrees they could, but no one is arguing that they have. And the only question is whether federal law makes it registrable. And so if federal law made it registrable, this provision specifically says the district court in Arizona must put it in the supervised release conditions for obvious reasons, because it would be a violation of SORNA to not register, right? So that's the whole reason that they have these like super short 10-day registration requirements and all of that. So is your position that federal law makes the 2421 offense registrable or something else?
I think that that is registrable certainly under state law,
And what would be your source of authority for that?
14th Amendment. So sorry. So all I'm saying is that it's not a due process violation if you ask someone who's been convicted of being a sex offender to register as a sex offender under Texas's sex offense registry. As long as the registry only says you're a sex offender and that's what you've been convicted of, that's fine. No due process problem.
Totally understand that.
Right,
My
that's
question-
Sandlin v. Connor, and you just look at the nature of the, so now if we're talking about was Texas following its own regulations when it gave plaintiff notice about the extraterritorial jurisdiction provision, and then was it looking at that correctly? I say yes to that as well, though I know that's.
Like this is not the reason that was given, though, to the district court.
I'm sorry, Judge Elrod.
I thought that the reason given to the district court was that it was federal and that federal says, and that that's what the district court ruled on. This is not that reason.
Oh, yes.
Am I wrong on that? This seems to me somewhat new.
I don't think so. So what I did see in my colleague's briefing was he was often kind of repeating the Connecticut v. Doe line. And so that was my reference to Connecticut v. Doe, which is just under the 14th Amendment, under due process, Texas is allowed to require someone who's been convicted of a sex offense to be on the sex offense.
Why isn't it appropriate if the reason that Judge Yackel gave not correct and the reason that you're saying now hasn't yet been presented and briefed and argued, to go back to Judge Yackel and you make this new argument that it's not because of federal, but that it's because of Texas?
Well, I would say that first I'd say that the argument that I'm making has been argued, right? Because, I mean, I can definitely provide supplemental briefing to connect what our briefs had to everything else, but I can also address the federal law SORNA thing. I just wanted to put SORNA in its place, because what we know is that SORNA is just a weak carrot for the states, right? So all that SORNA does is it tells you, here are the minimum requirements so that you can be SORNA compliant, which gets you 10% funding under the Omnibus Act. Less than 20 states are SORNA compliant. And so as Judge Davis mentioned, throughout the Federal Registry mentions or admonitions that the states can require more than SORNA does, right? So in terms of if there's a right that the plaintiff has that he can call on to say, well, if 5C says I get this consent exception, you have to give me the consent exception. Like, no, right? The state has discretion even under SORNA to take in parts of SORNA that it pleases. The state does not do that.
But don't you have a right to adjudicate that with the state at some level? And why do you say not? That the state can just say, we're picking this, and you don't ever have the right to test whether the state has been correct?
Well, and I think this goes to Sandlin in terms of looking at the nature of the right and not the regulation, but if we look at 209, 5A, his offense is listed under 5A as a sex offense, as a registrable sex offense, I'm sorry. And then we can decide how to deal with 5C. What we've decided to do with 5C is say, we're going to just assume you go under 5A, and we're going to think about, if you have some evidence of 5C, we'll think about how that would apply. You can see under the federal guidelines.
You haven't let them
I'm sorry.
talk about their evidence in a proceeding before the agency or whatever, you know.
So this is not a normal proceeding. If you had a case where it was the state, and if you had a case where you had a sex offender from another state, and he had a conviction for soliciting prostitution, and he moved into Texas, Texas DPS would make a determination as to whether it was a substantially similar offense, and that takes some analysis and some legal effort. And so there we do provide kind of a hearing. For when you're just pointing to federal law and you're just pointing to the military law, it's more definitional, right? Because usually there's just a list of statutes and a list of statutes.
But we found that there was no one who had ever held this particular offense was actionable. So that's really interesting if it's just right off. It's not a cookie cutter off the list kind of case.
So it is a cookie cutter offense, though. I mean, 2421 is listed as a sex offense under SORNA. And then there's an exception for all of the sex offenses that says if there's consent among adults or, a certain age gap. And the purpose of that under the guideline was to allow states that maybe had like Romeo and Juliet laws where there's some kind of high school romance.
We've had that case.
Right, or I think also...
I want to ask you a question before your time runs out. How did Texas go about opting out of the consent exclusion?
Right. We don't opt out, but we don't give everyone a chance to just have a whole hearing if they don't have some kind of...
I mean, what kind of notification or how did they go about doing it?
So we email, like usually what happens is probation or local law enforcement or some other entity will come to us with an offender who they want to see if this person is on the list or not. We respond and we say, this person is on the list. If they come back and say no, there was consent or something, we just ask, like, do you have some way to prove consent? Like, can you go back to the court or, can you get some kind of adjudication or something that, based on the facts that we have about this particular case and the fact that the plaintiff was a pimp and had only promised the prostitute that he wouldn't hit her, but he would take all her money, like, it would probably take more than just saying there wasn't consent.
But Texas had to exercise its discretion.
Right.
And who has authority to do that?
So we have to DPS. We believe this is part of DPS's analysis.
Part of what?
I'm sorry, we believe this is part of DPS's analysis as to who should be on the sex offender register.
In other words, this board has authority to make that decision? Yeah. Under what?
I'm sorry, what was that?
What says the board has authority to exercise that discretion?
So under Article 62, DPS has authority to determine kind of what's a registrable sex offense.
Okay.
So under Chapter 62, prostitution is illegal in Texas?
It is, yes.
Is prostitution amongst adults a registrable sex offense?
So
if it's committed in Texas under Texas state law, and convictions under Texas state law?
Aggravated, but aggravated is. So if we had more than one.
Right. So the view of the Texas Department of Public Safety is that something that is not registrable if committed under state law is registrable if committed under federal law?
Yes.
Okay.
It's just, or can I explain or?
Please.
Sorry, I was going to say, this way that the state Texas doesn't have to go and just case all the laws, right? As long as it sees that there's a reasonable law out there, so. Okay.
Thank you, Ms. Cherry. We have your argument. Mr. Gladden, are you doing a rebuttal?
Yes, and I'll try to be brief, but there's some important points I want to hit. In 2001, the Texas Department of Public Safety and its Sex Offender Registration Bureau was sued by an individual based upon a ex parte finding by the DPS on this substantial similarity. There's a separate category of offenses under Texas law that can require registration. For example, if a state offense is committed under state law in Arizona and its elements are substantially similar to elements that would require registration if committed under Texas law, all right? The district court, in two separate opinions, one in 2001, one in 2004, ruled that violated procedural due process because, number one, at the beginning of the lawsuit, they didn't say who was supposed to make the determination with regard to Judge Davis's inquiry. And then after they did it, they weren't providing notice and an opportunity to be heard before they made these ex parte determinations.
Let me ask you one thing, clear it up. Do you agree that if this opt-out provision had not been in the federal statute, the consent opt-out by the states, if that hadn't been in the statute, that a conviction under 117, 18 U.S.C. 117 would be a sex crime?
No, not unless it had elements of an offense. Or you're saying if the legislature wanted to pass a law that required...
Would that be a federal sex crime? That's my question.
Okay, no. And actually, I would take up something Judge Ullman said. Both the Wetterling Act before SORNA and SORNA both are geared towards two categories: sex offenses against children, that is the protection of children, and violent offenses. Okay? Now, if somebody committed a Mann Act violation that involved a child, that would require registration.
Well, my problem is that I read 34 U.S.C. 20911, going down to little 3I, lists 117 as a sex crime.
And it's possible it would, depending on the facts of the case, because of 20911(5)(c), which says if it's an adult victim, the sexual activity is consensual, and the victim wasn't in custody, it is not a sex offense.
I'm saying if you leave that out, if you don't consider
Okay, well, if that didn't exist, then I guess maybe it would be a stronger argument. The problem...
Well, I mean, why wouldn't it be a sex crime if the statute says it is?
Because the statute says it's not.
I know, I'm saying leave that out because of...
Okay, if my client had committed a sex offense, he would be required to register.
So you don't agree the state had the right to say, we're going to consider this an extrajudicial sex crime, even though it was a consent crime based on that regulation?
Not without procedural due process, and not when there is no statute.
What would be the issue? What would be the issue? If 117 said it's a, I mean, if that statute said 117 is a sex crime.
If it said jaywalking was a sex offense, I suppose that someone could be required to register under Texas law if they, in fact, had a conviction and it showed that they had committed the offense of jaywalking. But that's not the situation here. Texas law confines what's a sex offense in this context to what is a sex offense under federal law, under SORNA. And when you have situations where there's the exclusion statute, that is 20911(5)(c), where you've got an adult victim, the sex consensual, there's no custody or confinement, then that is not a sex offense under federal law. Now, you can say, well, let's just ignore that. Would it be a sex offense? Well, sure it would, because if that didn't exist, it would be a whole different situation. I wanted to talk...
Can I ask, did Ms. Cherry say, is it correct that it did not opt out of the C? Texas said it was being coterminous with federal.
It's not just coterminous. It all depends on whether there's a federal sex.
So this idea that Texas just didn't pick the C part of the federal statute, that's just not accurate.
The statute speaks for itself, and the answer is no, that's not.
And Texas did not say, oh, we're not going to adopt this. They said that they wanted to follow federal law.
Correct.
And that's what opposing counsel said, they were following federal law.
The statute speaks for itself. Now, one other thing I want to get to real quick. On the question of injury in fact, the other claim that we make is that the district court erred, not only by not giving us notice, but by confining what a liberty interest is and measuring it by the liberty interest held by people in prison. The liberty that I have as a person not in prison should be greater than someone who's in prison.
We don't have to decide all the stigma issues that are still hotly contested.
No, you don't.
Because,
Well, okay, first of all, Fifth Circuit said registration is stigmatizing. Then the question is whether the assertion of fact was false, and number two, whether the factual assertion would alter the legal status. Every court I've seen says when you're declared a sex offender, it alters your legal status and therefore complies with the Paul versus Davis, Constantinu versus Wisconsin standard.
That's because it affects where you can live and where you can go and that sort of thing?
Where you can be employed. You're disqualified. You go to prison if you don't register. That's kind of a difference than you or I would have as a status.
Okay, you need to wrap it up. Sorry.
Okay. That's pretty much all I've got. There is an Oregon District Court decision that deals with this issue expressly that says it's the government's burden of proof to show when there is a hearing. And I would urge the court to remand this and inform the district court I have standing and to proceed consistent with the court's opinion. Thank you.
Thank you. We have your argument. This case is submitted. We appreciate the arguments on both sides. This session of the court will stand adjourned pursuant to the usual order. Thank you.